Buenos días a todos. Es un gusto estar con ustedes en esta nueva
Good
sesión.
morning, everyone. It's a pleasure to be with you once again in this regional workshop on material transfer agreements and data transfer agreements. I'm going to begin with a brief introduction. First of all, I would like to remind you that for this session, we will have English-speaking presenters. So if you need to listen to the interpretation into Spanish, you would need to go to the globe icon on the bottom of your Zoom screen, click on that, and select the Spanish channel. That way, you will be able to hear the English presenter in Spanish, and now I'm going to say it in English.
If you want to listen to the session in English, please go to the little globe that says interpretation and click on English. Ahora bien, soy
Okay, my name is Carla Sáenz, Regional Advisor on Bioethics, and I'm in charge of the Regional Bioethics Program at the Pan American Health Organization, which is part of the Science and Knowledge Unit at the Evidence and Intelligence Unit for Intelligence in Health at PAHO. This is the third session out of a 4-session series, and on the screen you can see the information for those of you who are just now joining this series of workshops. This session is going to be on the roles, responsibilities, and challenges when using material and data transfer agreements. Our next and final session on October 31st will focus on regulations of material and data transfer agreements, which in the majority of the areas in our region are non-existent, but we could reflect on what kind of regulations we need in order to appropriately move forward using these agreements so they can streamline research, and promote specimen and data sharing in an ethical manner. You must remember that in our publication, Catalyzing Ethical Emergencies, Ethics Guidance, Lessons Learned from the COVID-19 Pandemic and Pending Issues, we need to focus on Chapter 6, which is how to ensure that samples and data are shared ethically for future research. So not only do we share data in emergency situations, although it is clear that when you are facing an emergency or an outbreak, collecting specimens and data for future research is even more pressing. So in the regional reflection session that we had to promote this publication, Catalyzing Ethical Research during emergencies, we reflected on the topics that are part of our regional agenda and the topics that we still needed training for. And this is one of the topics, material and data transfer agreements was one of the topics, and that is why we are holding this workshop and we are recording it for those who are not able to join us right now. They will be able to listen to the recording later on, and they will be able to not only listen to them, but also share them with their colleagues and agencies. All recordings, as well as all the information on our session and our work, the work that the regional bioethics program from PAHO does, is shared through our ethical research mail list. Through that red QR, you will be able to access our website where you will see how you can join our ethical research mailing list. I will be sharing the link to that list on the chat briefly, in brief. And I am also posting here the QR code to the website that contains that publication on catalyzing ethical research during emergencies. So not only will you be able to find the full document on this website, but also an executive summary, specific guidance for health authorities, specific guidance for research ethics committees or IRBs, and also you will find in both languages a set of slides or a slide deck that you will be able to download if you wanted to present the content of this publication, either totally or partially, to your colleagues or agencies or those who teach as part of their work. So without further ado, I am going to stop sharing my screen and I would like to now tell you a little bit about this specific session. For today, we are honored to be joined by Jeffrey Menzer. But before introducing Jeffrey Menzer, I am going to mention two things on things that we will need to clarify later on. One is, of course, we will be receiving questions, and to please post your questions on the Q&A section in the Zoom app, because that makes our job of parsing through the questions a lot easier, rather than reading through the chat. The second thing, before we begin today's session, is that you do not need to register any further than the Zoom registration. For those of you that attend all 4 sessions will have a certificate of attendance, but with the records of having joined our Zoom session is enough. That is to say, you don't need to submit any additional information. So now, without further ado, it is a pleasure for me to introduce Jeffrey Menzer, who has worked in the bioethics core at the National Human Genome Institute for over 20 years. He started off working at the Research Ethics Committee in that institute. He was actually the administrator at the bioethics core team, and now he is providing support on policy matters that are linked to these material and data transfer agreements. Also, topics related to share genome data and other institutional policies that have to do with sharing broader data. As far as his training, he is a nurse, and then in his postgraduate education, he studied health systems management at the George Washington University. He is also part of the Research Ethics Committee, or IRB, at the National Children's Hospital here in Washington, D.C. Jeffrey, it is a pleasure to have you with us today, and thank you so much for agreeing to be part of this session and for sharing your experience, which is so vast, and also the experience that your institute has, the NHGRI at NIH. So go ahead, please.
Great, thank you so much. Is this working? We had some technical issues and hopefully this is working now. I was fortunate enough to be able to participate in last week's session with Anna, who's head of the MTA office, Tech Transfer Office. So that was very helpful. Let me start And I have a note to speak slowly. So if I need to slow down, please let me know. All right. So what I'm going to speak to today is really how the bioethics core fits into the review of MTAs or material transfer agreements at NIH. I'm going to summarize some of what we went over last week, but also give a sort of a talk about how IRB or the ethics component of the MTA review process, and then talk more about the role of bioethics core in the review of data sharing agreements. I will discuss some of the issues that I've actually come across in trying to interpret consent forms and look at the wishes of the study participants as to whether or not materials could be shared and what restrictions, if any, would be placed on them. And then I can also review some templates that we use at the NIH for consent forms, as well as a manuscript on broad data sharing. It's the policy of the National Institutes of Health to share research results to the entire research community. In 2015, there was a requirement for the sharing of genomic data, and that has been expanded this year to require all grantees of NIH, including the intramural researchers who I deal with, to have a plan in place for more broadly sharing all scientific data. So that may be through repositories or databases that are restricted or unrestricted. But again, it is to all support the research enterprise, particularly since our research dollars are public monies, and there's the policy that that be shared as broadly as possible. So to start with, first a disclaimer, it's educational purposes, and none of this is the official position of NIH or the Genome Institute, nor am I providing legal advice. I'm not a lawyer, although some days I feel as though I'm acting like one. I have plenty of lawyers in my family, so I have enough experience with that. So I'm just going to go over what occurred last week in terms of Anna's presentation. That might be helpful. So the Office of Technology Transfer is one of the tech transfer offices of the many institutes at NIH. And as was described, they work with the investigators to identify patentable and research tools. They negotiate material transfer agreements, research agreements, and all sorts of other legal documents that address both incoming and outcoming materials, as well as some gifts. And they negotiate, execute licenses, and they also assist in marketing technology. I generally deal only with the material transfer agreements, which are used to transfer materials or data to research institutions only, although occasionally it does involve commercial enterprises. They're intended to be used only for research use. A license is required if there's a commercial use involved. But again, occasionally I'm involved in that process just to ensure that the consent form and the protocol are consistent with the intent of the transfer. Our institute has a bioethics review of agreements involving human materials, and I can show that process and where we interject ourselves into that. So as Anna explained, the process is really just an MTA template, which is actually a 2 to 3 page legal document that just describes the research purpose in the plan. It really indicates the confidentiality requirements. A blank version of the consent form is sent along. The one that was signed by the study participant, as Anna had discussed, some of the studies that we deal with are been in effect for 20 to 30 years. There have been considerable changes to consent forms. So what we need to do is ensure that the sample from which the participant, where it's coming from, is the actual consent form that was signed by the study participant. Quite often, participants do sign updated consent forms if they're involved in these long-term studies, but occasionally, sometimes they were signed 20 years ago, and that's what we're looking at, that document, which may or may not have addressed agreements for transfer. And then we've also, the NIH has instituted an investigator attestation, which I'll show you, which basically is affirming the investigators review that the consent on the protocol would allow for the transfer. And what we do here is that there's the review of the bioethics score just to assess whether or not the transfer appears to be consistent with the protocol and the consent form that was signed. So this is a flow chart that hopefully will be helpful. The MTA starts with the investigator initiating it. She or he signs the attestation. It goes to the tech transfer office, who develops the document that's going to be executed to allow for the transfer. That is reviewed by the IRB, the bioethics core. Generally, I'm handling that, although other people in the Coursera Hall also assist sometimes with the more difficult ones or the challenging ones. We often will meet and talk about it to sort of see what we can do. I mean, it is really our goal to assist in the transfer of materials, but we need to make sure that the participants' wishes are honored. The MTA is then executed, and then the material is sent to the recipient. And it's up to the investigator then shares the material or the data. Sometimes the MTA or the document outlines how the material is going to be shared. Usually data is restricted in terms to ensure that it's done safely. The MTAs that I've reviewed are sometimes only involving one sample, or a couple of dozen samples, or actually up to 100, depending on the nature of the research and who the collaborators are. And quite frequently, the results of the research on that material are going back to the investigator who provided them. Again, it's to reinforce that collaborative process. So here's just a copy of the template that's also available online at the Tech Transfer website. And it's, as outlined, it's pretty simple. It's the agreement is between the institutions, not the individuals. And in our case, it's NIH, which is part of a larger Department of Health and Human Services. The materials are pretty specifically described. The research project is described, usually in general terms, or sometimes it can be somewhat specific. And then there's just some limitations and condition of use, and basically how they can and cannot be used. The other pages just include some Confidentiality and Privacy Act notices, which are federal requirements. Going back to the description, often when an MTA is being negotiated, it gets revised because the description gets changed, and it's usually pretty specific down to what exactly the biologic material that's being transferred. Often the coded sample identity is there. Sometimes it then gets revised because they've decided to provide other materials. Sometimes MTAs that have already been executed do get amended because additional material is going to be provided to the collaborator. As I mentioned, our process also includes an investigator attestation, which has the description of materials, and actually quite frequently the MTA takes the materials verbatim from what the investigator describes. And then this option 1 is basically where the investigator is describing or affirming that the consent language does allow for the sharing of materials. And this here is where they also identify whether or not they will receive research results back that they can relink to the identifiers that the investigator has. Almost always, whatever's being shared is coded and de-identified. Or they may not receive the results back at all. Sometimes materials are sent anonymously, so results cannot be linked back to the source. Part two is whether or not, and I'm not sure I've ever experienced this, is they're sharing materials that actually were not collected at NIH under a protocol. So I'm now going to talk about sort of my role, or the bioethics review's role, in the data sharing agreements. And just to let you know about the bioethics core, this picture is from 2019, which was actually the last in-person symposium. We are having another in-person one now, but this was actually before the pandemic. And our role at the Bioethics Core, and it's a small staff, but we're housed within the Department of Bioethics for the Clinical Center of NIH, is to support the ethical and responsible conduct of research by fostering a collaborative culture of ethics throughout the Division of Intramural Research. And the DIR, the Division of Intramural Researchers, are NIH-based researchers. They're conducting research under protocols approved by an NIH IRB. They are a smaller portion of the entire research enterprise at NIH, which is mostly done through extramural research and grant agreements with external researchers. On a day-to-day basis, we consult with researchers, investigators at any stage in the design of conduct and research. We provide assistance in developing protocols and consent forms for IRB review. We help researchers go through the IRB process, as well as are available to provide ethics consultations if there are any questions that researchers might have, as well as through the whole MTA and data sharing process. A lot of my time is spent working with investigators now on implementing policies for genomic data sharing, as well as broader data sharing requirements that are just being implemented. The guiding principle, or what drives me, is that the original investigator and his or her institution have made an agreement with the subjects about the use of their biospecimens, and we have an obligation to honor that agreement. So it's really going back to that original consent form, that consent process in the protocol, to see whether or not there was a discussion and agreement around data sharing, and that whatever agreement was reached, that it be honored. It doesn't matter if the study participant is now deceased. We are going back to the original consent form that was signed when they enrolled in the study. So here's just a decision tree that's put out by our Office of Human Subjects Protection to help guide investigators in this. Can I share specimens of data from my IRB protocol for primary research, which is defined as the use of biospecimens of data for the original purpose? They're asked to review the protocol and consent form to determine if the planned research is addressed, and if it is, it can be shared. And if it's not, then some of the options are to amend the protocol, and if possible, amend the consent form to allow for the research collaboration. And it also would require generally reconsent of the individual to allow for that sharing. In the cases of secondary research, which is where data is being shared for something other than the original purpose for which the biospecimens or data were initially collected, it can be a little bit more complicated. Again, the consent form needs to be looked at, and there are various scenarios to allow or not allow the specimens to be shared. Again, does the consent form address the sharing of future research? And is it consistent with planned research, or does it allow for broad future use? Or often, if a consent is silent, for where there's no prohibition of sharing or no explicit sharing, then we can allow that that specimens be shared. If the consent really is very specific about how it cannot be shared, then the specimen data cannot be shared. And again, the protocol and consent could be amended to allow for that. And that is an IRB process. It's not something that occurs at my stage at bioethics, but often I would recommend that they consult with the IRB because they are the ones who've approved the protocol or the consent form. So some examples, and I'll have some examples of consent forms where consent language places limitations on future use. There, it precludes the sharing of any specimens of data. That's where it's very specific. We will not share your data or specimens. Sometimes there are limitations placed on who they can be shared with. Sometimes it's like we may share only with other investigators at the NIH. It could limit the type of research or analysis that could be done. Sometimes it might state we will do research only on this disease, or we will only do this type of analysis. It might limit the use for commercial purposes. So it might say, we will not provide this to a commercial enterprise, which, as I noted before, occasionally that is provided, but we do not sell specimens. And also what occurs is participants are often asked within consent forms to document whether or not they will allow sharing. They check a checkbox, which is an individual level limitation, which also needs to be looked at during the review process. Ideally, and where we're moving because of the requirements for broad data sharing, is that consent forms are now broad enough to allow for both broad data sharing in repositories or limited or public access databases. And therefore, something that broad could also generally be applied to an investigator to investigator sharing as well. So I'm also, as I said, I deal with consent with studies that are many years old when consent forms were written 20 years ago or 10 years ago. Many investigators, the feeling was that we really want to limit the use of data or sharing. Participants don't want this to occur. And it turns out that's not the case. Research has shown, and we believe that participants who are engaged in research really are altruistic. They want their involvement to benefit not only themselves, but other people as well. So I think what we're finding is that when asked, people really would like to have their data shared or their specimens shared, provided there are adequate provisions for confidentiality and privacy, and above all, transparency in what we're doing. So here's some, I'm just going to run through a couple of examples. This is from a consent form that I actually had to look at this month. It's rather old, I can tell by the font, but it basically says samples will not be used for projects unrelated to your family's condition unless you give us permission to do so. So this really could be seen as a disease limitation. We're not going to share or use your samples for anything other than your family's condition. And then here's another research limitation in the same consent form where they specify how they're going to use the samples. In the future, it is possible that your samples will be used for other research purposes that are not specifically outlined in this consent form. And there's a limitation. We would like to obtain your permission to recontact you in the future if other types of research methods different from the ones mentioned are developed. So here, in some ways, it applies a limitation or a process that might encumber the research or the researchers. Sometimes it's difficult to recontact study participants. So it really is best not to place these limitations or these promises that we're going to ask your permission again, because in the future, this is 20 or 30 years old, we're actually real life faced with decisions as to whether or not an MTA for this particular study can go forward because of what was signed in the consent form many decades ago, where the science has evolved so greatly, particularly in the area of genomics. Here's another example of a disease sample limitation. We, as well as other researchers within and outside the NIH, may be interested in using your blood samples to pursue other research projects related to GNE myopathy. So here we're allowing sharing, but again, it's limited to a disease. However, in the same consent form, it talks about submitting genetic data to a public database, which I also work with. So I have a question, does that disease limitation also apply to that database submission of genomic data? Because at one hand, they're talking about limitations of sharing blood samples, and here we're talking about submitting genetic data should there be a disease use limitation, which we do in dbGaP, which is a restricted genomic database. So again, it's really looking at the consent form in a totality. Often what might happen when people are writing consent forms, they'll borrow from old consent forms, they'll add another sentence because someone told them to, not always realizing the effect that might have on the entire consent form. Here's another example of limitations on specific researchers. This is actually an older consent form where only researchers at, this is another institute, and NIH can use the samples, or this would allow researchers at other institutions outside of NIH. And here's an example of a checkbox so that the participant in the study is being asked which they would prefer. So if a sample is being shared, the investigator would also need, this is the example of why it's important to go back to that specific consent form that was signed, because you need to know which preference that participant had. Here's another example of my feeling. This is when I sort of like, I'm not a lawyer, but maybe this is a little ambiguous. They're talking about confidentiality and how things are de-identified and coded. There's a sentence that reads, only members of the research team will have access to the data we have obtained. But in the next paragraph, they do talk about sharing the data that's been obtained. So to me, I'm asking, what does this word data refer to? Is it all data? Is it only the identifiable data? It's something that when the consent form was first written and reviewed, it might not have stood out, but when it comes time to actually carefully reviewing this and operationalizing it, it might be a word that's troublesome. Here's another example of, and this is a consent form that I had for another project I was working on at another hospital, where they do talk about how samples that are shared are de-identified, that they are coded. But then in the next bullet, it says, because all information and samples will be coded, it will not be possible to share any test results with you or your child's doctor. To me, are they confusing de-identification with anonymizing data? If something is coded and de-identified, then it is possible to at least know who the results apply to. It is possible to share. To me, it's more transparent to say we will not share results with you. Often the explanation is because these are research studies, and in order within the US for results to be shared, they need to be done in a particular certified lab, and often research labs and research studies do not have that certification that would allow for results to be given back to the individual. So again, it's just, are these questions that you might come across, are these contradictory? Am I overly interpreting this? But it's sort of some of the challenges that happen. So as I talked, some of the remedies when sharing is precluded or limited is that you can reconsent the participant who provided this specimen that with the consent form that allows for sharing. We've often had investigators successfully reconsent participants. Sometimes it's difficult to contact participants. So often only those who did provide that reconsent could have their sample shared. Um, Other options, and this has been used rarely, is that collaborator becomes a named investigator in the protocol, which would allow the specimens and data to be shared and engaged in the research consistent with the aims of the protocol. This happened in one instance where another NIH investigator wanted to have access to some MRI studies, and the consent form actually was limited only to investigators within our on the research team. So the solution there was to make that collaborator an investigator and part of that research team so he could have access to those data and assist with the research. So this was actually someone whose assistance was needed for the analysis of the study. It's just that unfortunately the consent form was limiting to allow the materials just to be given through an MTA. An MTA had to be done in addition to the protocol modification because we were transferring that from our institute to another. Other options, and probably not as good, is just to share summary data if individual data could not be shared. And sometimes you might need to see if similar samples or data are available from a repository. It may be easiest to get it from one of our investigators, but if it's not possible, are they available somewhere else or through another investigator? Often our investigators are working closely with people they know who they've collaborated with, so they really want to engage with that individual. So what we've consistently had are consent and protocol templates that have evolved over the years. NIH, about 5 years ago, centralized its 12 IRBs into a single IRB. And so that's assisted in the development of consent protocols and templates. And here's just an example of the consent template that's used at our clinical center. Um, and it really sort of explains how we'll share your specimens. It sort of gets through all the pieces of consent, that what we're going to do, what the risks are, how your confidentiality is going to be protected. And this is an example of it's broad enough. We're going to share them. Studies may be related to your disease or they may be unrelated. They may be at NIH, other research centers, institutions, or commercial entities. So again, this is an example of broad consent for sharing. If it does discuss whether or not, or people are given in terms of a repository, if it's an open repository or a closed repository, which means there's an application process to receive the data. One example here of checkboxes, and I found this was sort of interesting, is that another checkbox of allowing the sharing of data. And our IRB is requiring that if your study offers the prospect of direct benefit, that participants be offered the option in terms of this checkbox to share or not to share and how they can be shared. If there's no prospect of direct benefit, then it's actually not required to be a checkbox. I think the concern there is that people not be coerced into sharing their data in order to participate in a study that does have the potential to provide a direct benefit to the participant. And here's just an example of the template in use for the study. And this was an example of, this was not a study that had the prospect of direct benefit, but the investigator chose to have the checkboxes. So again, it goes back to if this individual's sample was going to be shared through an MTA, did that participant check yes or no? And it's just important to go back to that specific consent form. One of the things NIH did a couple years ago is create this document regarding informed consent for secondary research with data and biospecimens. So it was to provide some sample language for people to use to address the consent for the storage and sharing of data and biospecimens for the use of secondary research. So it does address a lot of repository use and to again allow the broadest use of data and biospecimens that were collected during research studies, both at NIH and through our extramural research program. So again, the process for sharing research materials should clearly outline the roles and duties of the various parties to ensure that it can proceed efficiently, responsibly, and ethically. So as I outlined, we've got the investigators, the tech transfer office, bioethics, and the recipients. I think the roles are pretty clear, and we actually do try to proceed efficiently. If there really is one that requires some further discussion, we often will meet about it. Otherwise, I review and sign off on things fairly quickly. Sometimes it's one study that is sharing a lot of material, so there's really it's a familiar situation. And it's important that be flexible to allow for the unanticipated situations while continuing to be respectful of donors' rights, wishes, and the understanding of their intent of participation in the research. Again, so maybe if there is some language that's unambiguous, that is ambiguous, how can we look at that language to really facilitate the transfer of materials without really trying to impede it? Again, we're trying to, if there's a balance, how do we come to something that everyone can agree to is the right way to move forward on things? And actually, that's the part that I enjoy. Sometimes it's these difficult ones that are the more interesting ones, and how do we learn from those situations in case it occurs again, or to also work with the investigators in how that they can improve their own processes. So I'm happy to take questions or listen to what anyone else has to share. Thank you very much. I hope this was helpful.
Muchísimas gracias, Jeff. Ha sido una
Thank you
sesión
so much, Jeff.
muy útil, muy clara.
This has been very useful, very, very clear. And what we're going to do is to hear comments from our panelists, and then we are going to have some time for questions from the audience. For those of you who have questions, please post your questions in the Q&A section rather than on the chat, because sometimes it's easy to miss them in the chat. And I will now give the floor to Dr. Maria Laura Garau, who is a doctor, a neurologist, graduating from University of Buenos Aires. She's a researcher, and she chaired the research ethics research at the Juan Fernandez Acute Hospital in Buenos Aires, and now she leads the Central Research Ethics in Research for the city of Buenos Aires, and she also leads the Teaching, Research, and Professional Development Unit at the Ministry of Health in the city of Buenos Aires. So, Laura, it's a pleasure to have you, and go ahead, please, with your comments.
Muchas gracias. Gracias, Carla.
Okay, thank you very much. Thank you, Carla and Jeffrey. Like Carla said, your presentation was very clear and very matter of fact in its content, not just for IRBs, but also for researchers whenever they need to write, informed consent forms for their research projects. Now, in Argentina, starting in 2020, we've had a ministerial resolution 2940, which provides for guides that ruled biobanks that handle biosamples for research purposes. So it includes not only how biobanks are supposed to operate, but also the requirements included in MTAs on informed consent forms and the content of such forms, like we heard in the previous presentation, and also how to use the SIOM guidelines. Now, in terms of the city of Buenos Aires proper, we do not have a biobank that's under the Ministry of Health and that meets the requirements mentioned in our ministerial resolution. However, just like with all health agencies, we have biorepositories. Now, this is a weakness we have in our system. We have a lot of work to do because it's not common practice in our hospitals, especially public hospitals in the city of Buenos Aires, to request consent for later use of samples that are stored or remaining tissue when they are collected for healthcare purposes. This happens only when there is a research process underway and all the approvals have taken place. So I believe that there's a lot of room for improvement here to make it common practice to obtain the consent and to have all these samples available for researchers throughout our system. Now, in terms of how we handle or treat data, the government of the city of Buenos Aires has a data management policy that rules governance from the moment the data is generated all the way to its final disposal. And that overall policy says that health, that except for emergencies or such as the pandemic, or under specifically refused, the samples may not be shared. Starting in 2016, we moved to electronic personal charts for public hospitals. We have 4 of these in our city, and this makes up the database of all the patients that are seen in those hospitals. So as we started using this system, we generated a significant volume of data. And then in 2019, from the Central Bioethics Committee at the Ministry of Health, together with the operational management, which handles health statistics, we developed a procedure to assess research projects that requested health information from the city government databases. This was passed through a ministerial resolution, and basically that set forth the requirements and the process to make such requests. So the process begins with a feasibility assessment of whether the data that researchers are requesting are available in that health database or not. For that, researchers need to fill out a form where they mention the project, objectives, methodology, and a very specific description of the data that they will require to collect from that database. Currently, the statistics management developed a tool so that after this feasibility assessment, we can use a tool to do an initial risk assessment for each request or application. So this tool was launched recently in the research ethics conference that we had last month. And I'm not going to belabor the topic, but basically they do an assessment that enables them to rate the request that they receive for health information based on the potential impact that this could have on people if the information is leaked or if there is a re-identification. So basically they said acceptable, somewhat acceptable or unacceptable, and sometimes that requires interacting with the researchers so that they can change the request variables, etc. For example, if they request data from the narrative section in people's medical charts, that's not acceptable. So it is very interesting. And so in order to proceed, they need to receive approval from the committee. And if it's for healthcare management, we also need authorization from the respective area. I believe that it is interesting to take into account that we are assessing risk when requesting healthcare information. And they are also developing a tool so that researchers themselves could have an idea of how risky the data they're requesting for research purposes actually is. And since Jeffrey mentioned the Children's Hospital, I wanted to ask him, in practice, how do you handle the situation? That is to say, when the samples that were obtained from children, once these children are of age, do you have to secure an additional consent? And how do you do it once the children turn of age? Thank you so much, Laura. And so now we are going to hear some comments from Dr. Carlos Alvarez. And after that, we're going to give the floor back to Jeffrey so that he can answer your question and supplement with any additional data that he may deem appropriate before moving on to questions from the audience proper. So it is a pleasure for us to have Dr. Carlos Alvarez in this session, who is a researcher with a lot of experience in multi-country and multi-site projects. He is a researcher at the Colsanitas Clinic and the School of Medicine at the National University in Colombia. During a recent COVID pandemic, he was the researcher responsible for the Solidaridad research trial in Colombia. So, Carlos, go ahead. Good morning, Carla. Thank you so much for the invitation. I would like to also congratulate Mr. Jeffrey for the excellent presentation that he gave us, and that explains in very simple terms what the experience from NIH is and their expertise in this very important area. I would say that I'm on the other end. I am the researcher. So rather than being part of IRBs, I am involved in research as a researcher per se. And in this sense, I welcome a lot of the recommendations made by Jeffrey, especially because sometimes what we see in this overwhelming amount of information is that it is hard to have a qualified process from the IRB that enable us all to speak the same language. So the clearer and the more that we speak the same language, the easier it will be for IRBs to do their work as well as for researchers to do their work. The topic of biorepositories, like our colleague from Argentina says, in Colombia, we have a pretty new legislation. It wasn't until January of this year we had a law that provides for or covers a lot of the items that Jeffrey mentioned. This is a national law, which is very good, but it's also very bad because all these processes are dynamic, but once you have a national law governing our activities, it's not that easy to make changes. So currently it's completely up to date, but maybe in 2 to 5 years it could be outdated and lagging behind. But for the time being, it is current and it reflects a lot of the concepts that Jeffrey presented. There is also an important aspect of data transfer, and that is that oftentimes we run into difficulties once we start interacting with different institutions and we interact with different ethics committee and share our point of view. And sometimes, some rift occurs, especially in terms of data transfer. I see this quite often. On the one hand, we have all the rules and regulations on data handling and how to handle confidentiality. And on the other hand, we have information coming from informed consent from the research study participants to be able to give permission for the data to be used for epidemiological research.
The trend we see most frequently is to use information from multiple institutions to obtain the data, similar to what WHO does, which allows you to have data, anonymized data, and have that information. It sometimes becomes difficult, and getting the permits and the permissions to obtain the data and from the donors, or the getting the consent form from them, may sometimes very difficult. Sometimes too, we see difficulties in the ethics committees and with researchers in the consents that are given for clinical care, and later that information is used as that data or that sample is used for research, no longer clinical, but later on some investigator may want to answer a question of particular interest. That's where we have a crisis situation. It's not very clear in that kind of a case where the person gives consent for clinical purposes. Another difficult issue is the whole question of artificial intelligence. There are more and more possibilities now for software to obtain information from data banks, from clinical histories, and as it becomes more and more popular, I can see that this can create great problems in having clarity as to being able to use information obtained through AI. I think there's a lot to do in our countries in that area. I think that our legislation, the one on samples and bank depositories, is being strengthened in our country and in other countries as well. And as researchers, we find that something which did not exist 5 years ago, that is the consent form, we're now having to apply to do clinical studies. But I still see that in obtaining the information and the data for epidemiological purposes, we are still having difficulties in consent forms and in how ethics committees interpret this. So I think that it would be helpful to have the region reach agreement on issues that are still not very clear here, but in other areas of the world, maybe. Thank you very much, Carlos, and thank you very much for insisting on some points that I think are key, fundamental in how we envisage these activities. First of all, the fact that we need to bring in different perspectives to the table. The ethics of research is not just a question of having bioethicists and research committees and ethics committee. researchers and the health authorities also have a key role. And at PAHO, we always try to push for a vision where you have a system where the different parts have different responsibilities. There's no magic wand where what that one can use to solve all problems. And secondly, that we do research because research produces knowledge that cures diseases, improves people's health, prevents harm. And that's why I liked it when in his presentation, Jeffrey talked about ethics, responsibility, and efficiency. In other words, to try to remind us of the importance of doing research and the benefit that comes from research when you assess and evaluate all of these mechanisms, because it'd be very easy to always say, no, you can't do this. But that means that you are denying the benefit that could have come from that research. And therefore, there is a value to, if it's possible to do something and do it well, then let's do it and let's find the way of doing it. So I wanted to underscore that. With this, now I'd give the floor back to Jeffrey. I don't know if you, there were some concrete questions asked, but I'm wondering if you also have some comments on the specific challenges that exist in our region, which both presenters talked about.
Let me go back to the specific question regarding children, and I can speak to what is done at NIH. As you know, we generally require the assent of children to participate when, I don't know if there's a magic age, but I would say 7, but I think it might be closer to 12. But then there's also the issue of whether or not, depending on the child and perhaps the disease, whether or not they are able to provide assent at all, if they're cognitively able to understand it. But it's always required also that a parent or their legal guardian provide consent. So there are 2 different forms, and I know in really the way I started in working with the IRB is I was doing minutes, and we sort of the minute is the record of the IRB's discussion and decisions, and my job or skill was trying to take people's very broad, vague statements and turning them into something specific and concrete. And often that was around the consent form, and really how do you simplify it, particularly assent forms. The assent form shouldn't be a 37-page document like the consent form. It needs to be 2 paragraphs. Fortunately, I never had to deal with what happens if the child said no, but at least the form would try to explain it in a language that they could understand. But the policy at NIH is that when a child who is enrolled in the study becomes 18, that they provide their consent to participate, to continue participation in the study. If they have an illness that really cognitively they're not able to provide that consent, then they actually need to have a legally appointed guardian. Often it's their parent, but again, that consent process needs to go on. In the instance of the IRB does provide sort of an exemption to that. Generally, if you're just doing data analysis, if you're no longer actively seeing that individual, but if you're continuing to see that person in clinic, if it's a longitudinal study or an interventional study, then consent needs to be provided by that now child who's now able to legally provide consent. One of the other things that sort of makes NIH unique too is that in the United States, we are not governed by the broader HIPAA law, which is what covers privacy and confidentiality in healthcare institutions. We are covered by the Privacy Act, which I believe dates back to 1974. So there's different requirements and assurances. institutions, healthcare institutions that are covered by HIPAA and other consent forms are also broader because in HIPAA, you also need, when I go see my doctor, I just basically have to provide a consent. Often people feel that doesn't at all allow the sharing of data, which is not true at all. I know during the pandemic when people were being asked to show their vaccination card. Oh, you can't ask me, it's HIPAA. And it's like, no, you certainly are allowed to show your data. It's basically you need to provide consent or permission to allow that to be shared. And as an individual, I actually do public health research. I've had to sign agreements with the institutions that are doing the research that I'm a covered entity and all this other stuff. I think part of it too, in terms of the interplay with biorepositories, I noticed a question in the chat. I think it's the position, particularly at our institute, that we really want to know where everything is going in and out. If something was collected at our institute, it's the tech transfers office to know where that sample has gone. We've had investigators who've operated outside of it. And basically, when that's been discovered, we've had to remedy the situation. And it's not done in a punitive way, but it's like, hey, didn't you realize you needed to get an agreement to do that? And basically, we do it retroactively. And occasionally, we run into some difficulties with some of those. And it sort of becomes non-compliance. But again, it's really to ensure that there's integrity, I would say, throughout the whole process. I think some of the issues that we're confronted with in terms of sort of the research enterprise or science is, the unfortunate situation that that's happened in terms of public regard for science and research, and whether or not what kind of effect that's had on people's willingness to allow sharing of data. And some of this is also done within the whole context of the HeLa cell and Henrietta Lacks and the legacy that we have dating back to the 50s, which is sort of, I think, becoming or has become part of sort of the public knowledge, perhaps, or at least within certain people. But again, within the research community, again, it reinforces the need to really comply with what is expected at the time. I mean, what was done in the 50s is different from what we know is proper to do right now. So I don't know if that helped answer any specific questions or not. I mean, you're dealing with multi-country, different systems that I operate within a day-to-day basis, and often I'm so narrowly focused that I appreciate being narrowly focused most days.
Creo que es muy interesante desde nuestra perspectiva escuchar también.
I think that it would be interesting to hear your perspective on how a research center at the highest level functions, such as an NIA institute that has resources which many of the research centers, I would say most of the research centers in Latin America and the Caribbean, don't have. So, for instance, you have an office on technology transfer, which does not exist in many of our countries. From in addition to the IRB, you in your institute have a resource extra ethicists that support the work of the IRB. Then at one point you referred to ethical consultants or consultation you have, which is another resource you have. Just like you do a consultation on pediatrics, you can actually have a consultation with ethics specialists. And that's extremely useful, I think, in a case where you can see that there's much more depth and to the question, and a much more formal group of ethics specialists would be necessary to answer it. So in our region, how could, as our region moves towards more research, to trusting research more and to try to accomplish more through the research we do, from our perspective, it would be interesting to hear how this could be possible in the future. So let me start with some of the questions that I see in the chat. And I'm going to try to condense them and group them because there are many. And I'll try to give priority to those that have to do with a specific MTA and or DTA agreements, because there are some other more general questions. But I also wanted to make a comment, which is that when Jeff was showing the old consent forms, well, not that old, some of them were 10 years, but the consent forms that you have to evaluate and analyze to see if you are really representing the will of the person who signed the consent form. How do you deal with the fact that the original consent form was not very clearly written, or was ambiguous, or sometimes contradictory? So how do you deal with that? Particularly, we need to remember that we need very clear, precise language that makes it easier not only to obtain the consent from the individual for that study, but also so that it becomes a document that really honors the will of the patient in the future. So from that perspective, those of us who work in ethics committees feel that it's important to do this very rigorous analysis and to be careful to look at the language. Many of the times where we deal with consent conform, informed consent documents, as Jeff said, they took into account previous consents, but they didn't do everything in a consistent manner. And therefore, from the perspective of the researcher, the support for them when we scrutinize the consent document, because not only helps the present, but also the future, this leads to a question on informed consent specifically, which is, when you're thinking of sharing samples or data, what is the role of being very specific about the different types of materials that one is willing to donate for future studies? Or is it suffice to allow for all sorts of materials? Or do you have to specify exactly which materials can be used in the future? If broad consent is given, do you give it for all samples, or is general language sufficient, or do you need to have it for each specific sample?
It's best to not be specific. I think broad consent is broad consent. There's some of us who really feel that checkboxes should not be used. It often creates sort of an administrative nightmare, particularly if you've got multiple checkboxes. I think one of my colleagues' research has really shown that people don't always know what they're checking. And if they're asked it, and if they're asked in a different way, they might have a different answer. So I think there are many reasons not to be as broad as possible, because we also don't know what, and to be future thinking, which is what you said, is we don't know what the future's, going to bring in terms of what kind of analysis that can be conducted. The thought of bringing AI into this horrifies me. There's so much that's going to happen. I think people really feel hindered by some of these restrictions because, again, people might want to conduct some research that or use a sample that in their consent form there's some sort of restriction to. On the other hand, there are reasons not to share data or allow people not to share data. One of the things I didn't mention in our country also, there are issues around sort of community feelings or community ethics within our Native American or indigenous populations. There's the sense of the community may not want genetic data shared, and that's sort of some of the exceptions that we do allow if an investigator does provide a scientific rationale, and often that goes back to we've worked with our community, and their feeling is we will participate in this research, but we don't want our materials or our data shared more broadly. And often that is accepted and allowed and supported by policy. There are vulnerable populations that are protected by our research ethics regulations. So again, it's that balance, how not to go too far. We would never conduct research on pregnant women. Well, we see what's happened with that restriction. I mean, again, we thought we were doing well 30 years ago with some of these restrictions we put in place, but now we know that actually they're perhaps more harmful or deleterious to the research enterprise. So it's hard. It's hard. We can't predict the future. We sometimes maybe want to take the easiest way, which may not be the best way. And then there's really just these practicalities of consent forms. I've seen it again and again where people, early researchers or fellows, people early in their process, it's like, I've never done this before. Give me a sample. They go to a colleague. Oh yeah, this, got approved 10 years ago. We're going to use it. And then suddenly the IRB gets it and like, it's not approved. Well, it was approved 10 years ago. Why aren't you approving it now? And it's like, well, there are many reasons. It could be from the committee's completely different and someone had a bad day to like the regulations have completely changed. So again, it's really being thoughtful and looking at things. To me, it's just important to look at things in a totality and making sure that we're consistent and transparent.
Gracias, Jeffrey. Carlos, ¿quieres complementar? Adelante.
Thank you, Jeffrey. Carlos, would you like to supplement? Go ahead. Are you giving me the floor? Yes, I have two things. Once again, I would like to congratulate Jeffrey for his excellent presentation, and because it also illustrates the importance of common sense. Sometimes it's not just doing things, the wrong way, but rather to make what makes sense. And in terms of what Carla was saying, I don't know if there are informed consent forms where you could have a broad consent, but also give an option to the participant to opt out. That is to say, to give the participant to be giving this option. So basically have a broad consent, by default. And if the participant does not agree to that, then, offer options. Yes, in fact, reflecting on this concept of common sense, which tends to be the least common of all senses. In general, the majority of the people, if they trust the research team to an extent that they allow a blood sample to be used, they also trust to allow a urine sample to be used or biopsy material. What I mean is that in general, what common sense shows that it is the trust what determines the willingness, rather than if the sample comes from my saliva, from my skin, or what have you. In general, that is not the issue that most people bring about when making decisions. However, here there's something that Jeffrey mentioned that is also related to a comment that was made in the Q&A section. If we know that we are working with the community or we serve a population where there are certain cultural or ancestral views, for example, around blood, common sense dictates that for that specific case, there needs to be an additional exception. I believe that we cannot come up with a silver bullet that would work in all cases, but rather take into account the diversity that we deal with and try to be looking at the bigger picture to the extent possible. Another question that people asked today has to do with the content of MTAs and whether they should refer to intellectual property rights of the results or modifications that could be made to the original sample, or whether in general that should not be part of the content of these agreements. And also a question about in what specific cases do we use these agreements, and is there anything unique or different when the agreements relate to transfer not only between agencies or institutions, but rather from an institution or agency in one country to a counterpart in another country. So in that case, what roles do borders, international borders play? Is that something that is specified, or is it treated as any other case?
That I actually can answer partially. Again, I only see what I'm given by the Tech Transfer Office, and they're dealing with patents and all sorts of things that I'm not really that involved in. They are patent attorneys, but I do know that we do have MTAs with samples being sent to institutions in other countries, and that they're direct with that institution. One of the things that and it's the same agreement. The agreement that we use is rather simple. I think it was 2.5 pages, so that's pretty much the standard one. The CRADAs, the collaborative research agreements, are much lengthier. Things are laid out. There's often financial issues addressed, as well as royalties and patents and future discoveries and all of that stuff. So I think a simple transfer is a simple transfer. I mean, they're really being done to do an analysis on a particular individual. We have a very large undiagnosed disease program where people with very rare or unusual, generally genetic disorders come in. There's an attempt to try to find a diagnosis, and often these are things that are shared throughout the world, really to help in that endeavor. I'm just trying to, there's one other thing. Oh, Carla, one other thing you mentioned too. There sort of is this hierarchy of sharing too. We had one study where the consent form had pretty much our boilerplate language relating to iPS cells, and sort of we generally have a couple of paragraphs about what they are, how they will be used and not be used, whether or not you can withdraw consent. Generally, for an iPS cell or a cell line, we explicitly state we may not be able to withdraw this once it's been developed. It's very expensive, it's difficult, etc. So we're, again, another example of being upfront. But this particular consent form was very good at addressing that. Didn't address something as simple as sharing blood or urine. So I think our sense was they've consented up here. We can certainly feel that they would have consented to something much more minor than the sharing of of cells for iPS development. So you know, it would be nice if it were comprehensive, but it wasn't. But to us, this was an example of the consent was adequate in that instance.
Y creo que es un excelente,
Yes, and I believe that this is an excellent example. We have talked about trust and the fact that some significant components from this transfer, even if there are agreements which are legal in nature, rely on trust. So some people wonder what happens if on the receiving end, those of us who receive a sample, or the sending side, there's a break in trust. For example, if there is the break in trust when you are about to give samples and you fear that the studies or these new future studies that may be done by a different institution may be performed without the scientific or ethical rigor that should be in place. Or whether, on the contrary, if when you receive samples, if you receive samples but you suspect or you have certain questions about how ethically this initial collection was. So what do we do in these cases where there is, let's say, reason to believe or suspicion that we should not trust the use that will be given to the samples you give, or in the way in which the data or samples that you received were collected?
I was going to say, if any, I mean, that's a hard one. I mean, I think my experience has been more along the lines of they were collected so long ago, we don't know. They were collected under an approved research project that was conducted at an institution 30 years ago. So I mean, I think we need to trust and assume they were. If there's specific evidence that they weren't collected appropriately, then that's sort of, I think that really depends on the context as well. I mean, if you're asking, should they be used if they weren't collected ethically, you know, that's a huge question that's been asked about many samples. So be happy to hear anyone else.
Adelante, Carlos, y no sé si Laura, tú quieres agregar algo más también.
Carlos, go ahead. I don't know, Laura, if you have anything else to add. Carla, what I believe is that this is part of the cooperative work that we do and the trust. When we work in this area, you trust that the others are committed to following ethical principles and to abide or comply with best clinical practices that govern research. So if we have questions about the way in which we're working together because we suspect that some criteria have not been met, then I think we should leave that relationship, you know, because if I need to process data, maybe I will no longer work with data or samples from that institution. Or, you know, there's no more trust and no more collaborative work. So in doubt, like with many other aspects of life, we have to, you know, make these judgment calls. In our previous meeting, we also, with Anne, this also came up. We have to trust, right? And institutions and regulatory agencies and governments need to earn that trust from the public, right? Because that will determine their willingness to participate, because people need to trust the institutions or research agency or biobank or whoever the recipient of those samples or data is. So we need to build that trust, and you do that with transparency and the trajectory of the institution, the way in which it communicates results, also to be open and honest with our citizens, so that again we generate trust. In addition to what Carlos was saying about trust within the research group.
And the reason why NIH requires the sharing of data is so that there's replicability of a study that's published. Our investigators in intramural, they know that in order, once they have a paper accepted, they need to share their data. So that's where a lot of our data sharing agreements come into place. And it's really part of the research enterprise. Just this past year in the popular press, I mean, there have been 4 or 5 significant research studies that the questions have been raised about the manipulation of data. It is interesting how one student journalist sort of uncovered something. So it's sort of like, we're all involved in this very large ecosystem, and we have to, I guess we alone we're not fully responsible, but everyone has a role to play in that. And I know last week Anna said yes, we can give samples and people can provide assurances, but we're not in that lab. We're not seeing what happens with everything. We do need to trust. And perhaps if something were done improperly, there's another check and balance down the road that could perhaps check that if something was used in a way that it shouldn't have been, if there's manipulation of the data or something like that. So things do get through, but it's also nice to see that there are these checks and balances. It sometimes does affect public perception of research, but we really should also see that, no, it actually helps support the honesty and the transparency of it.
Gracias. Hay un par de preguntas sobre temas.
Thank you. There are a few questions about topics that have to do with the use of data sample from ancestral communities or indigenous peoples. And the question is, Jeffrey, how do you handle those cases in the United States? This question, I'm trying to merge some questions and combine them so that it could be like more of a conversation rather than a question and answer ping pong, because all these questions have to do with the issue of trust that we have been discussing. Because I don't know if everybody knows, but we've had a few experiences in the region, more specifically in recent years, with samples taken from the Guarani or Guarani. I'm not sure if I'm pronouncing this correctly. The Guarani indigenous community in Ecuador, which were initially taken unethically. However, the people that did future research assumed that those samples had been obtained ethically. So there was a cascading effect of issues because of one initial bad decision. So now thinking about the samples from indigenous communities or First Nations, whatever name you use, and taking into account that the use of genetic data that may allow researchers to identify the community, what kind of reflections could you share with us, and what suggestions, Jeffrey? And Adriana Granizo from Ecuador is clarifying that is Guarani. The indigenous community is a Guarani community. The one that I was trying to remember.
This particular area is an expertise of Sarah Hall, so I would talk to her about this. She's head of the bioethics core and has done a lot of work on this recently. I personally don't have a lot of experience with it other than I know that we've worked with Native communities in developing their IRBs and entering into collaborations. One of the IRBs I worked with is in Phoenix, Arizona, has another clinical site in Phoenix, Arizona, which is home to many Native Americans, and there's an Indian Health Service hospital. So there's collaboration that's going on there within the context of under the purview of the IRBs. So I think part of it is really that the research is conducted under the IRBs, and often it requires collaboration between IRBs to ensure that the community is involved in decision making, that the research is reflective of the community's wishes, and sometimes that's through an advisory board, through working with the other IRB, and really actively soliciting comments from the communities in which you're working with.
Sí, ciertamente, y no sé si Laura o Carlos quieren agregar algo sobre este.
Yes, I don't know if Laura or Carlos wish to add something on this specific topic, but in other words, issues about involving the community, not just whatever precedes an informed consent process are the wishes of the community. And in today's times, we value that much more than we did 20 years ago when we didn't talk about it. And when we didn't, because we didn't talk about it, we often treated the communities as if they were just a geographic space, and that's not how we should have considered them. Now we're fortunate enough to have new guidelines. SIOMS, for instance, has a specific guideline on involving the community to find out what the community's interest is. Something that we often don't talk about is that very often there is a relationship between the research team and the community, which is long term. And I'm thinking specifically of the case that Jeff was referring to, because when I was at NIH, as part of the ethics committee of NIDDK, the National Institute of Diabetes, Digestion, and Kidneys, there was a lot of continuous and ongoing dialogue with the Pima Indians, because in fact, they even had an installed capacity to do research in that Pima community. And the dialogue was very enriching, actually. In fact, there was a moment where the leader of the community said, I don't want my community to participate anymore. And we had to call on an ethical consultation because the rest of the community did want to participate. So I think there's still a lot of work to be done in the area of involving communities with which one is doing research. Now, we at PAHO, for instance, don't talk about involving the community without first clarifying that community involvement is not exclusively for the purpose of including indigenous communities in research. Very often they would say to us, why do you continue talking about community involvement? This study is not about indigenous communities, but we believe all communities need to be consulted and incorporated and involved and taken into account when research is being done. Taken into account their differences. Carlos? Yes, indeed, Carla. I think that's what you've just said is a very important comment. In the last few years, in my research, I've found the importance of involving the community in the research project. What we do is invite the participants and we describe the research project and obtain the consent. But getting them to understand the work of the clinical research, but even field research, and having the community understand what we're trying to do not only makes our job more successful, but the guidance we provide is more effective. So I think that's a very important component. So just as we worked in the preparing the cold chain for vaccination and in working with the community on different operational procedures for the researchers, it's just as important to take into account that community where you're going to be working and doing this. Laura, I see you took your mic off. I just wanted to comment. On the involvement of indigenous communities. It's very difficult to hear her. In some areas with regional committees, before we initiate a research project, we have the community, indigenous community, to participate, which is something that some years ago was not done. And the fact is that now it has been extremely helpful. For instance, another community is the disabled persons with disabilities. They feel, don't make any decisions about me unless I'm involved in the decision-making process. And I think that's a very accurate statement. Thank you. I am copying here the links to SIOM's guidelines for those of you who are interested in the international and updated guidelines, so you can read more about this. There's still a lot of time left, but there's a few questions about, as you know, Jeff works at NIH, which is a research center, where all of those who go to NIH are people or patients who are covered by a research protocol. But as we often know, very often samples or the data are, well, let me go back. The research protocols are one of the many ways we can obtain data and samples for future research. And very often these samples and this data come from a clinical practice. That's what happened with COVID. You go get your COVID test and that what's left over can be used. It has the potential to be used in research. Sometimes you obtain samples for epidemiological surveillance purposes. Well, those samples are also have the potential of being used in research. But that's a different scenario from where you get the first sample for research protocol purposes. These are two different scenarios. One is when you are being treated or public surveillance is being done and the sample is obtained. And that presents challenges in our region because in many cases, particularly in the area of healthcare, we are not used to having informed consent forms. So we lose that opportunity of asking the individual, hey, I'm doing your COVID test. Would you let me use this sample for future study? Yes or no? It's an opportunity that is lost, really. And so in an effort to maximize the impact of research, we now have to start thinking about creating informed consent, broad informed consent processes, so that those samples can be used in future research. So, what work should we do now to make ethical research take place more easily in the future? In the case of epidemiological surveillance, very often the samples or the data is not obtained through informed consent. And it's not because of ethical inaction, but I think in order to do this, we should look at the guidelines on the ethics of public health, that some that are available in English, Spanish, French, and Portuguese. And not always does public health necessarily consider obtaining informed consent for a sample or for data in order to protect the population's health. But if I were to need this for purpose A, surveillance, can I say for this purpose, for this surveillance purpose, I'm going to have to take this sample? I'm not going to ask you, I just have to take it. But I could ask you, in addition, would you allow me to use it for future research under these conditions, etc.? I think that's something we're going to have to start doing and looking at in our region. We're going to have to start thinking about the many different areas and activities that we can carry out to encourage research and to support research. You'll see that in the public health surveillance ethics guidelines, there's a specific clause that talks about whether you should share surveillance data for research purposes. And the answer is yes, if you do it correctly. It has to be done ethically, efficiently, and responsibly. In order to ensure efficiency, one way to do it is to obtain consent for that purpose from the very outset. And sometimes we should remember that consent is not private property for research. It's just a way of proceeding that attempts to treat people in a respectful manner by allowing them to voluntarily participate. Now, of course, not everything in life is done voluntarily, but where it can be done, such as volunteer to participate in research or any other voluntary activity, well, then it should be done with the proper amount of respect by asking the person and letting the person decide. So, since we only have a few minutes left, I think that there has been a very enriching session, and that has given us a lot of food for thought, a lot of pending issues still. It's not the last one, though. We have one more session for this workshop next week. And so I'd like to ask our panelists, and Jeffrey in particular, if you have any further final comments you'd like to share with us before we close the session. So I'll begin with Carlos and Laura, and I will conclude with Jeff, and then we'll close the session. Go ahead, Carlos. First of all, thank you for allowing us to have this space and to learn from the very interesting speaker and topic we discussed today. I think it's important for many of the countries in our area to proceed at the same rate so that we can proceed more quickly, because normally what happens when is one country's behind and is not proceeding at the same pace as the other countries, then it ends up serving as an obstacle, as a barrier to prevent the kind of research we want to have. So we all need to proceed at the same pace. Laura? Yes, I'd like to thank you for this workshop. It's been very enriching. And I think that we need to be ethical, efficient, accountable, we have to have transparency, and also what Carlos said, that since we have participants from so many countries in the region, it's important for us to begin to coordinate and work on developing concepts and developing the same language so that we can cooperate at a more regional level. Thank you. Jeffrey?
¿Alguna reflexión final?
Any
Thank
final
you.
thoughts?
Yes, a few things. One is thank you so much for this opportunity. I think this has been really interesting. Just to go back to some of the discussion before with communities too, is just to remember that I think the feeling among communities is that researchers come and they take and don't give back. So it's always how to involve people in the process. It's involving people from the community working for you also, so that can be shared. I was going through a lot of the questions. Thank you, Google Translate. And they're like so wide ranging between the incredibly technical small ones and the big questions. So I think we've tried to operate at multiple levels today. It's kind of what makes this all very interesting as well. And I know that you as a collective group have really been looking at this, have a lot of challenges just given the diversity within all of the countries involved in your systems. Just because, and again, you know, NIH in some ways is unique. We live in this, if anyone's ever been there, it's this enormous campus. And it's like a huge sort of university that where it's all focusing on one thing. And for many years, I only had to go to one room, and that's the only place I could ever find. So again, I really appreciate the opportunity. Some of the real technical stuff around MTAs, the tech transfer web page has all the templates and the examples, and ranging from the real simple stuff to, I think, the more complicated stuff. So I'd encourage people to go there. And I think that link was shared last week. But again, thank you so much.
Gracias, y gracias a todos los participantes y a todas las personas que están atrás de las
Thank you, and
bambalinas.
thank you to all the participants and all the people behind the screen allowing this session to be possible. Thank you to our Cosicas, Silvina Cosa, Marnam, and the interpreter, Cecilia Nidet. Thank you very much for allowing us to dialogue, even though we have different languages. And we will continue with the PAHO Bioethics program and continue to do the work that is needed to continue to promote ethical research, which is what improves health and the well-being of people. And the less effort we have and the more coordination and collaboration we have by researching and working together, the better off we will be and the more people will benefit from the outcomes of this research. So again, thank you very much to everyone. We will continue doing our work. We'll see you next week. And those who haven't yet signed up to our list of ethical research, you can do so by going to the webpage of the Regional Bioethics Program, because we will be hosting other sessions. In addition to this workshop, we have other sessions planned for the rest of the year. For instance, we are going to be hosting a workshop on the difference between ethical supervision, which is what ethics committees do, and regulatory supervision, which is what the national regulatory body does for clinical trials. So thank you once again, and have an excellent afternoon. Thank you, Jeffrey, Laura, Carlos. It's been wonderful having you here today. Goodbye. Have a good day.